Welcome to the Ncast, the podcast where we bring you the sharpest minds in compliance, risk, and regulation, and make sense of what it all means for financial organizations navigating today's environment. I'm Rafael DeLeon, the Senior Vice President of Industry Relations at Ncontracts. Having spent decades as a bank examiner and watching regulatory expectations evolve in real time, I can tell you the conversations I find most valuable are the ones that don't just explain what the rules say, but what it actually looks like when institutions are getting it right and wrong. Today's conversation is going to be one of those. My guest is Hollie Mason, Managing Director with Stout and their financial services area, and Stout is a global advisory firm. Hollie brings a wealth of experience and something that's genuinely rare to this conversation. She has sat on every side of the table. Hollie is a financial services expert and advisor with Stout. She has spent her career at the intersection of securities regulation, enforcement, and litigation, presenting cases before arbitration panels, courts, and regulatory bodies, conducting regulatory investigations, and advising on rulemaking enforcement matters. Before her consulting work, Hollie served as a senior enforcement counsel at the Financial Industry Regulatory Authority, FINRA, where she held members accountable to FINRA. She's also a certified FINRA dispute resolutions arbitrator for more than a decade and spent years as an in-house legal counsel for major financial institutions, handling complex brokerage, clearing, and investment advisor matters. In short, Hollie's done a lot of these things, and she's either enforced it, arbitrated, litigated it, or advised on it. Hollie, welcome to the Ncast. We're really glad to have you.
Yeah, thank you. Good morning. It's great to be here and great to have these conversations because typically they're very structured and court related. So it's nice to be able just to chat.
Is there anything I missed in your bio that you want to bring to our listeners' attention?
It was pretty comprehensive. The only thing I would say is that, on the RIA side, since that's what we're talking about today, I did serve as chief operating officer for a smaller IRA, which, it had 12 to 15 investment advisors, those that were state licensed as well as registered with the SEC. They did insurance products, estate planning, the regular, securities trading as well. So that's another sort of perspective that I bring to this, which I think your description was pretty good in terms of sort of that 360 view of the industry. So
good. I appreciate it having, like, as I said for myself, been on both sides, having started off working at banks, then working as an examiner, and now on the board of directors. So really seeing it, from all perspectives as well. But I'm really glad to have you because we've got a focus on wealth management and registered investment advisors, wealth, managers, and what's going on. Can you give our listeners a quick snapshot of what you're seeing on the ground right now and what's keeping those compliance officers up at night?
So I think it's no surprise. I think that most folks in the industry, wherever you're seated, are, keeping a close watch on, fraud related issues and, risk management in general. And I think, we're seeing those where, if they're shifting from, your retail client to maybe your relationships with vendors. So I think this administration, as well as, sort of the messages that they've been putting out, everyone is sort of focused in on, those fraud related issues, as well as, customer harm and all of those, which sort of plays into standards of care. The other thing I think, I've been hearing about is the SEC's task force on, sort of RIA sweeps that have this insurance arm. And they're looking at it, and the SEC is always looking at conflicts of interest, but I think this one has a little bit different twist to it in terms of conflicts of interest. And so that's another one that I think people are keeping their eye on. And again, conflicts of interest is always, something we're focused on. And anytime you're a dual registrant or, you have another business arm, or even in the instance where you have maybe your CCO is also your CEO,
Right.
or plays dual roles in, and a lot of the mid-sized firms as well as, some of the smaller firms, that dual hat is necessary. And, but it just requires a little bit more thought and planning in the risk management area.
Well, I agree with you. I think a lot of these issues, and one that I also want to talk about is here is what we're seeing around AI, what we're seeing with vendors in particular. So there's really a phrase that's really kind of floating around in regulatory circles that the existing rules already cover it, and regulators seem to be saying they don't need new AI specific rules. Do you buy that? What do you think of that? What does that actually mean for some of these RIAs and broker dealers that are trying to figure out where the guardrails are?
That is a great question. And I think, it sort of starts in the Wayback Machine, if you will. It's not that I don't buy the regulators' approach to this. I think that, it's one that's has historically been taken. And it's, technology neutral. We've heard it out of regulators' mouths for a decade. And, while the SEC had a little rule making, proposed rule concerning conflicts and AI, I think, generally, they are this technology neutral. And I'm sort of dating myself maybe, but if you go back to, like, for example, like 1998, we had when everyone was sort of saying, can you really send my statement via email? Can you really send my confirms via email? And so, those things we had, notice to members, and we had, and then if you go forward, we had the Knight Capital case, right? With, the SEC in 2013. So all of these are, technology updates. We're not strangers to technology updates in, this industry. And I think it's a position they've taken. And I think the important part here is to say that it's not about the rule, let's follow this rule. What ends up happening with this approach is that just like in, the Knight case or all of these, notice to members, we started seeing sort of rule by examination. And I know that that has also been a topic of conversation in other circles, that the SEC says they're not going to do that anymore. There's going to be some cooperation, but in this instance, I think with AI and technology, I think that's what I think we can expect with these examinations. And maybe it's just a heads up to begin with, but enforcement and these things, we're really going to get the guardrails from those activities. And that's not just me saying, that's a decade of historical data on the various different steps we've taken in this technology universe.
Right. Well, I think it's great to frame it just even in just technology, because what the spillover has been, and where I see some parallels, albeit a little bit different, but is around vendors and vendors' use of technology. And on the banking side, I've seen and watched the evolution of kind of these rules with vendors, vendor management come into place. But for at least uh, banks and credit unions, following that, we've moved into more of a plug and play dynamic and area. Whereas before, everybody was tied to a core, so you weren't really having to manage multiple risk. And now, with a lot of different companies coming on, and they're having access or may access customer data, and how that impacts, that those crown jewels of the organization. I see that, like, with again with banks and credit unions, that they've had 20 years to kind of learn this and get up to speed and kick and scream the whole way, like we don't really need to do this. And yet we've seen with breaches and other attacks that really you have to know who you're dealing with, and in the same area. So I do see those parallels, and then now we with technology, we're also talking about cybersecurity issues and how they impact whether the institution itself or through the vendor. That goes back even to the Target data breach that we saw, and then with AI. So you layer on these complexities that a lot of vendors and companies are taking on, and it does create some concerns. So if you had to point an RIA compliance officer to the three rules they should be watching most closely as they evaluate or implement AI tools right now. Record keeping, disclosures, conflicts. Which ones rise to the top and why?
Well, I think all of those are at the top of the list, and just because that's what we're seeing, and not necessarily in enforcement necessarily, but we're seeing it in notices and guidance from our applicable regulators, and so I think they're seeing things that they don't like, or repeated issues in these areas, and so they have said that this is what we should pay attention to. And I think, in rule based with AI is again back to there's, this technology neutral, all the rules, apply, and they apply just fine to this new technology. But I think, there's some principles here that we can, take away. And I think that's where firms are focused, is these principles. And, we've been helping firms with checklists and things, and, prioritizing. But as, I think we're going to, talk somewhat later about the, third party vendors, but, being aware of technology limits, establishing, an AI governance, and not replacing vendors for in-house sort of knowledge. You have to have some in-house knowledge to be able to, function and identify those risks, and, knowing where your data is, just like the record keeping, and, having a strategy, I guess, is, sort of these principles that sort of all encompass these rules and these points of interest you pointed out.
No, I agree with you. It really always goes back to strategy in any case. What are we doing? What are we going to do in this situation? And what are we going to do if? And that gets right back to business continuity planning.
And it's easy to sit here and say, yes, have a checklist, and yes, but I do say that they start conversations. And since these things are very, business tailored, and, or offering specific, then, you really just do have to have those conversations with the right people in the room, and creating, your own risk profile. And, again, we start those conversations with firms. We may see something they don't, or, just from an outside perspective, but having the conversations is a really good place to start, and keeping an eye on where regulators are, seeing issues.
So, on that, where regulators are seeing issues, both the SEC and FINRA have flagged fiduciary duty, cybersecurity, and AI as top examination priorities. And there's real overlap between the two regulations in this space. For an RIA, what does that coordination actually mean in practice? And are firms looking at a double barrel examination risk?
So, and that's another great question, and another very way back machine historical sort of complaint in the industry. And even when I was at FINRA, that's something firms identified as a real sore spot. And I think there's been some really good developments on that front. But, you said, looking at FINRA's priorities and the SEC's priorities, and even state priorities right now, because, some of that, enforcement and various different topics have sort of fallen to states, just because of the SEC has other priorities or other things. So again, we're dealing with a lot of, folks that have overlap. And in terms of, the SEC and FINRA, I think the SEC has come out and said they're going to try to avoid this overlap. But, I think you're right. I think firms are still going to see some overlap. And just based on my experience as a regulator, call it out. Like, say, because, as much as we, as a regulator, try to stay connected, sometimes that's just not, possible. And, saying, look, we've done this before, we're doing this now, we just disclosed this, here's our production for this, is very helpful, and is not going to give anyone pause on that side. I would say that's just my experience, but call it out and just don't recreate the wheel if there is some overlap there. And with Reg BI we've seen overlap, and I think fraud we're going to see an overlap, AML we're going to see an overlap, and whether it's policies and procedures or it's processes or those types of things. I think truly, as much as we avoid it, and we think everyone plays in their own space, and in these, I'm going to enforce this side and you enforce that side, industries are enterprise, and you're talking about banks and owning broker dealers, and you're talking about broker dealers having RIAs, and so there is a lot of overlap in terms of even just the corporate structure and who is related to who, and so I think we're still going to see some of that.
And that really gets to managing these risks because they're important to you, not trying to play to what the regulators are going to be looking for and asking. Because I know from my vantage point, and I'm just seeing this again recently, is in the absence of regulation, you have different examiners, different people from different sides where there is overlap, asking different questions based on there may be some synergy there, but each one has a bias and thinks that certain things are important. So if you're trying to play for that, you're going to be getting a lot of different questions depending on who is asking the question, and you can't always assume it's going to be the same person.
And that's a great point, because it's like chasing your tail almost in terms of that. So we always help clients sort of have a basis,
Right.
an explanation, to say and to understand the reason behind the decision, and the person sitting in the seat, whether it's compliance or otherwise, understanding I'm pushing this button for this reason. And most of the time that thoughtful process and those documented decision points and those things are more important than trying to predict with a crystal ball who's going to ask what question on one topic. I do know, again, sitting in the seat inside firms, they do look at those very carefully, just because it's a conversation, again, internal, to say, hey, we should maybe take a look to see if any of these things pop up for us. And that's, that establishes sort of those customary practices, those, standards, talking to your industry folks to say, how are you handling this? And so it starts good conversations, and it also flags things that may not have been on their radar because of interpretations or before things they're seeing. So.
Well, financial services firms like yours with Stout really end up being a good kind of clearinghouse because you've got a lot of customers. They're sharing with you what they're hearing from exams. And so you have a better understanding to share with more of your clients across the board. And really in terms of that and these areas of overlap, where do you think firms are most underprepared right now?
That is a great question. And I think generally, I'm seeing sort of this gap in third party vendor oversight. And I know that we're, again, talking about that in the context of AI. We're talking that in the context of other things too. But I really do see that. And whether it's, lately I've been seeing with on the litigation side that a lack of sort of documentation about oversight of that third party vendor, for whatever reason you have them. And I'm seeing some pain points there with documenting, for example, choice, right? Or understanding the capabilities, or again, you think your third party vendor or your third party relationship is doing this function, and it ends up that they're not. Or so all of those clarity issues that come with working with other industry partners or third parties, I'm seeing that come up over and over again.
Yeah, I'll come back. We'll come back to that when we talk about some of these third parties, but I have my own theories on really what starts to shape that. Um, FINRA has flagged that AI-driven communication needs to accurately describe how services incorporate AI technology and balance benefits with appropriate risk disclosure. That's a pretty high bar. How should RIAs be thinking about that explainability?
Yeah, and I think that goes back to, you know, knowing your technology and understanding where that sits and what it actually, how it functions, um, and sitting down and really thinking about, things like conflict and conflicts, and also then, because most of, disclosure, we're talking about, again, conflicts of interest, or communicating with folks about, what you're really offering. And so I think, some of those things to say, represent what you're representing to your clients, always client facing. We know that that's at the highest risk, right? Anything client facing in terms of AI functionality is always going to be under a microscope and at the highest risk possible. So just just being aware of where your technology fits in that scale of risk, and then making sure that, again, you're aware of those functions, and making those proper disclosures to your clients so they can make a decision and understand what's happening if they use that, or how you're using it. And so it is really just about those conversations internally, and thinking about it from whether it's the client perspective or conflicts perspective. But yeah, I think just even addressing it.
Well, in FINRA's 2026 oversight report, they specifically call out hallucination bias and cybersecurity risk as control areas firms need to address when deploying generative AI. And we're seeing that. We're all seeing that. And I think people in the market are excited and fearful at the same time. They're excited because it looks like a panacea. It's going to help me with a lot. And concerned because we don't really know all of these concerns. I think, again, we've been talking about hallucinations for the last past year. We've seen that ourselves if we're user of that technology. So, what does that, look like in terms of defensible AI governance look like for wealth management firms?
Yeah, and so I know it's a really great tagline, hallucinations, and I kind of like it because it sort of says, it makes it exciting to talk about. And being in this industry, compliance, risk, it's so boring sometimes, whether you're at the dinner table or at work or whatever. But to make it exciting, hallucinations. So hallucinations for RA firms and those things, and folks on that level, it's really about, again, back to understanding your technology. And it's, again, it's the learning part. If you're not using Gen AI and learning applications, that's different. But most firms we're talking to and assisting, we're saying, look, having a policy and explaining what technologies are available and how that information is, processed, and how it's used is pretty important, and controls who needs to use it, who doesn't, and those types of things are important. Hallucinations really just means that your technology is taking in information and learning from various sources, and so again, it's creating information from the information that you're inputting. And so again, that's a check and balance to say, is that really accurate? And I think FINRA and the SEC have also, said that, look, you're not going to replace human oversight and interaction, which is, again, conversations that need to happen to say, at what point do we need somebody looking at this? What is, what is this technology creating, and when do we need that oversight, and that person sort of at that escalation point.
And we're still seeing these issues pop up in the news with larger firms, how they've been impacted by data that was incorrect or that had been, there were hallucinations in there. I do like the term. I didn't ever think we would be talking about
Oh
hallucinations.
no.
Exactly. But what does this mean? But I think it really, bottom line for our listeners is this just said this is a tool. And how does this tool perform? And we have to constantly calibrate it, check it to make sure it's working for us and giving us the responses we need. And so it kind of it puts the onus back on us. And what type of QA are we doing around any outputs from AI?
And from our perspective as experts and consultants, and myself as a lawyer, we're looking at it too from that perspective. And I think you're right. And, some of the, first cases or slaps on the hand we're seeing, and, whether you consider them slaps on the hand or not, but, lawyers are being sanctioned, and experts reports are being thrown out. And it's because of the way that they have implemented, relied on, or can't explain their use of AI. And in our universe of litigation, we're looking at, rules of evidence and those types of things, and, reliability of, findings and data. And so all of those things are the reason we're seeing these outcomes. And it is really about, we have, I mean, cases in New York and Delaware and, Minnesota talking about, chatbots and experts testifying that I'm not sure how we got there. And so again, it is a lot of clients, and we're actually, as a firm, talking about how we're using AI. And, I've had clients say, we're not in a position for you to use it, so you can't use it at all because we don't want to go down that road. And I think you're going to see that for a while until we see, the impact in our federal rules, as well as, seeing maybe some best practices that are give us a little more guardrails in our universe. So you're right, we are seeing some repercussions in other areas, outside the regulatory world, where folks are not quite grasping the implications of using it.
Well, I think in any tool that we're using, we really need to, especially in the financial services space, need to be able to defend our position. Is it auditable? Is it accurate? And when you were
Yep.
talking about compliance, and again, how that kind of can get boring at times, the problem is you can't be only 80% right, because over time that just creates more and more problems for you. And you were basing something on an answer that was 80% right. So where do we go to find that information? And I don't think, as generative AI is still new, people are not understanding these questions to really understand.
Yeah, and I think FINRA does a really good job of defining, in their their materials, each what they consider the each type of AI, right? And I think so firms can have good reference points. And I think again, the SEC has just formed a group, and talking to the industry about AI usage. And at least our surveillance of the industry is that most folks are really dipping their toe into it, for whether it's reviewing documents, or maybe advertising, or just small snippets in the process of other functions. And I think the regulators are interested in how this is going to develop, how firms see themselves using it, who's spending the money on developing their own versus third party vendors. But all these conversations are happening, and so, but it's developing quickly. So even our conversation here, on this recording, will be outdated next year, because it's firms will be using it differently, and there will be different issues. And so, yeah, these conversations are really important. And I think, having assistance or getting assistance if you don't have the expertise in house, or seeking that view of what other people are running into, whether it's industry committees, or whether it's talking to similar folks at firms that look like you, or if it's hiring consultants because they see other have other clients, and they kind of have a handle on the issue from various different vantage points. Whatever it is for you, that's it. It's important to stay engaged.
Right. So when as we kind of switch over and wind down around third-party risk management, FINRA has really called out third-party risk as another return priority for 2026. Indicating that a single incident at a critical service provider can affect large segments of the industry. And so for a lot of AIs, as you mentioned a minute ago, they're either going through the spend of, building their own, but the majority are buying tools from vendors rather than building in-house. So, from your legal kind of point of view, what type of due diligence questions should they be asking before they sign that contract?
Yeah, and I think, it starts with your initial research as well, because I don't know about you, but, I get emails with, vendors that can do this with AI or can do that with AI. And it's very, it bombards me in terms of how many firms are out there doing, things with AI or can help you with, these things. And so doing that upfront, sort of taking a look at, vendors that are established and they have the security protocols. And, so it starts with that sort of due diligence and asking those questions about, their use of data, their, privacy policies, their, again, the cyber structure. So and then having everyone at the table. I
Right.
know when I was in house, nobody wanted to come to legal, but involve them and compliance and risk, and sit down, and and business partners too, and say, let's vet these and see, do they have the functionality, do they have the security we need, and sort of go through that process, and selecting them, and select somebody that has a reputation and has worked out the kinks. And then you kind of get a sense too of um, oversight and how that works and what you're going to have access to. And when you're asking those questions and sitting in a room and deciding on vendors, to say, how are we going to do this process? We have this process for oversight. How does that fit in to our relationship with you and structure? And contracts are important in identifying access and parameters and what they will be doing versus what you'll be doing. It also helps understand when you're telling regulators, look, we've hired this third party. We understand what they do, they understand what we do, and this is what we're using it for and how we've implemented it. So I think all of those questions are important, and particularly in identifying what type of vendor, who to go with. And sometimes that depends on what AI function you're going to be utilizing them for. Some are very specialized and some are more general. And that's a conversation, from a business strategy standpoint, or, do you want 5 different vendors, or do you want one that can do everything? So those are the types of considerations, that conversations that are being had. And, I think people who are considering it in terms of third party vendors.
I think one of one of my last questions here is, you were talking about vendor oversight, but what does the minimum viable oversight program look like? And my theory is that this has really been shaped by a lot of class action lawsuits that have been out there, because every data breach that has happened or breach, there's a class action lawsuit. And I keep advising customers that I'm dealing with is like, it's not the regulators, it's your practices. And you just touched on that a minute ago. Do you have a process for looking at your vendors? So give me your take on that.
Yeah, I think documentation about that is key, and even statements. I've worked with firms that don't even have a statement in their policies that say we rely on this vendor for this function, or we've delegated that to the over we've delegated that process to this vendor. And so it's important to identify who is doing what, make sure that you can delegate that, and also then identify that in how you're overseeing it, and again being clear and documenting the fact that that's what's happening. I agree with you on the the class actions for sure. I think they are sort of and that's on the retail civil side, of course, and like you said, the regulator side is I've seen when not too long ago we were asking the question, when do we report, like 4530, there was some issues there with, gosh, you're going to get reports every 5 minutes if this is the standard. So there were conversations around that too. But I think when do we disclose, when do we have to put that incident in our public 10Ks, or when do we have to do a special filing?
Right.
So the conversations are happening on the regulatory side with that. And like you mentioned earlier, even with AI and disclosures, those conversations are happening. But I want to close with one thing that I think, from a third party vendor selection, and whether it's AI or anything else, because I know that that's a focus right now for everyone. I think, you asked about questions that they should ask. And I wrote down some things that I'm seeing, and wrote down, some things that I think are important. And when you're considering vendors, or even you have a vendor, even just doing, a revisit of these, what's their change management process, right? When they implement, they change things, right? They change how it looks to a customer, how they process things, where they store their data. They add things. How do they communicate that to you? Because they may not necessarily know how that impacts you from a disclosure or regulatory standpoint. So having that conversation with those vendors is important. Technology, support, expertise, right? If you're relying on their expertise, what does that look like? And if you're relying on them for technical support, say you do have a cyber incident, or you do have a down, function that clients can't use, or hey, look, we have to do this, supervisory process, and this thing isn't working, or whatever it is. Just what understanding what kind of technology support and expertise that they have that you can lean on, because that will shape what you need and in terms of expertise, as well as how you communicate, and how you sort of your business continuity planning. All of those things are sort of interrelated. And then I think when I was looking at vendors in-house, it's always that relationship or ecosystem, or how are they going to connect with your firm? Is it behind the firewall? Is it just clearly a third party? Or how is that going to fit into your processes generally? And it's always good to have a vendor that is willing, because our industry changes so often. This, like, regulations change all the time. And so to work with a vendor that understands that, and flexibility, and has some capabilities to build out things that may be required because things change, or even industry things on your side, like change in product, or change in client focus, or all of those things. You want to have those conversations to vet and see what that looks like.
Right. Well, Holly, this has been exactly the conversation that I wanted to have, and I think it is helpful for our listeners. Very direct, practical, and grounded in what's actually happening on the ground. So, thank you for your time today. Thank you for sharing your expertise. And until next time, stay engaged and stay proactive. Thank you.
Thanks everyone.